Thank you for knockout crypto. A judge rules today that ICOs are covered by U.S. securities laws. This was the big news that a lot of people seem to think that this was the reason why we saw the market downturn that we saw today. Um, Covered by Bloomberg Crypto covered this as well, and so did CCN. A U.S. district judge in Brooklyn has delivered a landmark judgment with far-reaching implications for the initial coin offering market. Judge Raymond Dier of the U.S. District Court of New York today ruled that U.S. securities laws covers ICO token sales. The ruling came in a case against a fraudulent ICO promoter, Maskin Zalaspi, who prosecutors are looking to bring up on fraud charges for defrauding investors of more than $300K from a scam ICO called Recoin. In 2017, September, CCN reported that the SEC charged Slabowski and two of his companies with defrauding investors through a number of ICO scams, including Recoin. Recoin was marketed to investors as being backed by real estate and diamond assets, which in actual fact did not exist. In a pioneering ruling, Judge Dier refused to dismiss the case against Slabowski, whose lawyers earlier pleaded for dismissal on the basis that the ICOs in question were currencies and not securities, placing them outside the jurisdiction of the SEC Act. An excerpt from today's hearing file reads, Slabowski, argues that the securities laws are unconstitutionally vague as applied. Government, meanwhile, asserts that the investments made in Recoin and Diamond were investment contracts and thus securities, and that these laws are not unconstitutionally vague. Judge Dier's ruling on the matter was that an ICO is indeed a security for the purposes of federal criminal law, which is what prosecutors have argued since last year. Implications of Dier's ruling. Dier has become the first judge to deliver a ruling that places ICOs firmly within the jurisdiction of securities regulations, and this could potentially have important implications for the ICO market by creating a precedent for future cases. While the CFTC has had some success tackling fraudulent crypto offerings within its space, the SEC, which has long said that its jurisdiction over most ICOs, the SEC has long said that it has jurisdiction over most ICOs, has not yet established this authority in court. An excerpt from Judge Dier's ruling reads, Zavasky's contrary characterizations are plainly insufficient to pass by regulatory and criminal enforcement of the securities laws, because the indictment is sufficient under the Constitution and the federal rules of criminal procedure, and because this law under which Zavasky is charged is not unconstitutionally vague as applied. Zavasky's motion is denied. The case will proceed to trial. While the ruling comes as a boost for prosecutors, it is by no means a final word on the matter. In his comments, Judge Dier noted that the ultimate decision rests with a jury, and that Zavasky's lawyers can in fact still present the argument contesting the jurisdiction of security laws to the jury. So wow, this was big, and it really places, ICOs are covered by securities laws, which really places a lot of scrutiny on ICOs. About $18.7 billion has been raised this year by so-called ICOs, according to data compiled by CoinSchedule. Securities and Exchange Commission Chairman Jay Clayton has said the fundraising method should be regulated, adding that he believes the market has become rife with fraud and has quickly expanded with the popularity of digital currency and blockchains. This ruling affirms the SEC's position that it has authority over ICOs and that the market manipulation and anti-fraud provisions in the law apply. Peter Henning, a professor at Wayne State University Law School in Detroit, said in an interview. The defense here is arguing that it was not a security, but the judge has rejected that claim, saying that this case can fit under security laws, and that is an important first step. Per the indictment, no diamonds or real estate or any coins or tokens or currency of any imaginable sort ever existed, despite promises made to investors to the contrary. Dier said in his ruling, simply labeling an investment opportunity as a virtual currency or cryptocurrency does not transform an investment contract, a security, into a currency. Federal regulators have urged investors to be cautious with ICOs and stepped up efforts to police the market for digital tokens, which companies and individuals have used to raise billions of dollars for projects or ventures. After a record $5.8 billion was raised in June, according to CoinSchedule, the pace has cooled as the prices of Bitcoin and Ether have tumbled. Clayton has repeatedly said that the vast majority of the offerings should be registered and that the coins trade on secondary markets like other securities the SEC regulates. But ICOs have been slow to subject themselves to agency oversight, and just a relatively small number of issues are moving to register. In a January interview, Clayton placed the sanctioned more firms if people don't change their ways. So as you can see, the court is now hearing ICO cases, and this could really crack down on cryptos and really give regulators a win seeking more market control. So this will be out there to protect investors from fraud. So this is a good thing. I think we do need more regulation, especially in the ICO sector. We have had a lot of fraud ICO. We're never going to get institutional money if we don't have regulation. So that's going to come. So thank you for following Knockout Crypto. Let me know what you think about the video, about the ICOs are covered under U.S. security laws. This is a big ruling. It's the first time a judge has actually said that, and it's going to affect the market in a major way. Thank you for following Knockout Crypto. We're on Instagram, Twitter, and YouTube. Like the video, subscribe to the channel, comment. Thank you so much.